and public safety, which aims at better understanding the European framework on privacy and data protection. I hope that you will enjoy it and find it useful, maybe for your practice. So I'm a lawyer at Bird&Bird in the Paris office, and specifically in the tech and data department. So I practice technology, privacy, data protection, and cyber security law mostly. So let's start with the webinar. So it will be divided in two parts. The first one will be the key principles of the GDPR and an introduction to the GDPR, and then we will go further into it with the how to comply and the steps to comply with the GDPR. So recently we had a new European data protection reform package, which is composed of two texts really important, which is first the General Data Protection Regulation, directly applicable in the member states of the European Union as of May 25, 2018. And the second text is less well known than the GDPR, is the directive called Police Justice Directive, which regards the processing of personal data by the competent authorities for the purposes of the prevention, investigation, detection, or prosecution of criminal offenses or the execution of criminal penalties. So maybe it does not really concern you, but it's another really important text that is currently applicable across the European Union. And in addition to this data protection reform package, there are guidelines from supervisory authorities, such as the guidelines from the European Data Protection Board, which are quite important to have a light and more guidelines and interpretation of the GDPR. So what are the main objectives of the General Data Protection Regulation? The first one is to modernize the existing regulations by replacing the directive from 1995, which is quite old, considering the new technologies that are now used, like big data, artificial intelligence, profiling, etc., etc. We needed a new text to apprehend all of those concepts. It also extends the scope of application of the privacy rules. The GDPR is really broad and broader than the previous directive. The second goal is to give better control to EU citizens over their personal data by reinforcing their rights of the data subjects. There are new rights that have been specifically created. The data subject needs to be more informed of what people will do with their personal data. This regulation also increased the administrative penalties to make the rule more effective. Actually, the GDPR is not really has not brought a lot of new rules. Most of them already existed under the previous directive, but it was not always applied. So now that the administrative penalties are really high, it will be more effective. And then the third objective was to unify the rules, allowing for greater consumer trust by ensuring the free movement of personal data within the EU and having the same level of protection across the EU. Of course, there are some specificities sometimes that the GDPR may allow, but the legal general framework will be the same now. So now the sanctions. So first is the administrative fines. So you have two levels of administrative fines. The first one is that you can be fined up to 10 million or 2% of the worldwide turnover of the company for the breaches that are like the absence of records of processing activities, the failure to notify a data breach, the failure to conduct a PIA, etc. And the second one is up to 20 million or 4% of the worldwide turnover, for instance, in case of non-compliance with the consent requirements, the lack of information notice, the non-compliance with rules about transfers outside the EU, etc., etc. So, for example, if you have navigation and case management application for emergency vehicles like ambulance, which collects personal data, you must ensure that it is correctly secured under the GDPR, and a failure to comply with this obligation may be subject to administrative fines up to 10 million or 2% of the worldwide turnover. So in addition to these administrative fines, you can have all other sanctions provided for in the legislations of the member states of the EU, such as criminal sanctions. For instance, in France, along with these administrative fines, we have criminal sanctions with imprisonment sentence for the representative of the companies, and all other fines which are criminal fines, so a different nature, but that the companies can be condemned to. So now the GDPR key principles. So there are 6 main key principles to comply with the GDPR. The first one is the lawfulness, fairness, and transparency of the processing of personal data. The second one is purpose limitation. Third one is data minimization, accountability, storage limitation, and security of the processing of personal data. These principles lie at the heart of the GDPR. They are set out right at the start of the legislation and inform everything that follows. They embody the spirit of the general data protection regime. So, lawfulness, fairness, and transparency. So basically, lawfulness means that before processing personal data, an appropriate lawful basis needs to be identified. We will see then in the webinar in a few slides what are the appropriate lawful bases that can be chosen. It can be consent, it can be protecting the vital interests of data subjects, for instance. Then the fairness means that personal data should only be processed in ways that people would reasonably expect. The transparency is making sure that the data subject has been informed of such processing. So transparency is fundamentally linked to fairness. Transparency processing is about being clear, open, and honest with people from the start about who you are, how and why you use their personal data. You must ensure that you tell individuals about your processing in a way that is easily accessible and easy to understand. You must use clear and plain language when informing the data subjects. So what you have to understand here is that GDPR is not about strict prohibitions in how to use the personal data, but it is more about putting the individuals more in control of their data. Therefore, transparency and information are really important in this respect. Purpose limitation, so means that you need to have a specific, explicit, and legitimate purpose for processing personal data. So you must be clear about your purposes for processing from the start. meaning what you intend to do with the data. You need to record your purposes as part of your documentation obligations and specify them in your privacy information for the individuals. And then you can only use the personal data for a new purpose if either this is compatible with your original purpose, or otherwise you will have to get a new consent, or you will have to have a clear obligation or function that is provided for in the applicable laws. The purpose limitation principle prevents you from using personal data for new purposes if they are incompatible with your original purpose for collecting the data. For instance, if you collect health data for providing care for an individual, you cannot send the data to an insurance company for other purposes, for business purposes, etc. So before processing personal data, you need to ask yourself, why do I need to collect such data? Do I need to use the data for different goals? And are these goals compatible? Data minimization. So Article 5 of the GDPR say that personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. It is the principle of data minimization. So what you need to do to respect this principle of data minimization is to only collect personal data that are really needed for specified purposes, to delete the personal data that are not useful for the purposes, and to periodically review personal data in the database and implement the relevant purge and deletion of the data that are not necessary. So you should identify the minimum amount of personal data you need to fulfill your purpose. You should hold that information, but no more. For instance, recently the CNIL, which is the Data Protection Authority in France, has opposed to several projects involving facial recognition in schools for security purposes or in the city in general, because the technology, according to the CNIL, of course, is not necessary and not proportionate to the objective pursued. And the CNIL has considered that less intrusive means could be used instead, like badging or things like that, but not facial recognition technology. Accountability. So accountability is really important, and it's really new from the GDPR. Before that, you had no such principle. So in the accountability, you have two key elements. First, it makes it clear that you are responsible for complying with the GDPR. And second, you must be able to demonstrate your compliance. So you have to put in place internally a number of measures to show that you respect the regulation. It means that you have to maintain a record of the processing activities that are pursued by your company or the data controller, adopting and implementing data protection policies, taking a data protection by design approach, putting written contract in place with organizations that may process personal data on your behalf, maintaining documentation of your processing activities, recording and where necessary, reporting the personal data breach, and carrying out PIA if necessary. PIA is a privacy impact assessment. We will study it later in this webinar. So you need to know also that the accountability obligations are ongoing. You must review and where necessary update the measures that you put in place. So accountability means that you now need to be really proactive about data protection and always have in mind that you need to evidence the steps you take to meet your obligations and protect the people's rights. Storage limitation, it's not a new obligation, it's an old obligation. It was in the previous directive, it was in the French law before that, and in most of the European regulations. But now that GDPR has increased the sanctions, it is an obligation that you must take into account. So it means that you must not keep the personal data for longer than you need it. You need to think about and be able to justify how long you keep the personal data. This will depend on your purposes for holding the data. You should also periodically review the data you hold and erase or anonymize it when you no longer need it. However, and it's the difficulty, it's that the GDPR does not dictate how long you should keep the personal data. It is up to you to justify this based on your purposes for processing. You are in the best position to judge how long you need it. However, you should know that the European Data Protection Board and maybe your local data protection authority will issue some guidelines that will recommend some data retention periods, and then if you don't follow those rules, you might be at risk, because you should follow the guidelines from the data protection authorities in most cases. So, for example, you should consider your stated purposes for processing the personal data. You can keep it as long as one of those purposes still applies, but you should not keep data indefinitely, just in case it is forbidden, or if there is only a small possibility that you will use it. This is not allowed. You need to have a defined purpose of processing, and you cannot keep data without any goal behind that the data subjects are informed of. So, for instance, when setting data retention periods for processing related to emergency services, you should ask yourself, how long do I need this personal data to manage emergency situations? And do I still need this data after the emergency situation has been managed? For instance, in case of litigation or police investigation, if the police investigation can ask you for data like 1 month after the situation or 1 year, then you have a good reason to keep the data in your systems. Now, regarding the security, GDPR requires you to put in place appropriate technical and organizational measures to implement the data protection principles and safeguard individual rights. It is called the data protection by design and by default. This means that you have to integrate data protection into your processing activities and business practices from the design stage and through the life cycle of any product or service. So GDPR does not define what security measures to adopt. It only gives example, and it is you to assess the risk, to say that and to appreciate the level of security that is relevant to the processing in question. Okay, so it is an example. So if you are a service provider, when setting up an emergency service application, you need to make sure that first, you consider data protection issues as part of the design and implementation of systems, services, products, and business practices. You make data protection is an essential component of the core functionality of your processing systems and services, and that you only process the personal data that you need for your purpose, and that you only use the data for those purposes. Okay, so It's a global summary of the GDPR timelines, but just to show you that two major sanctions have been issued. There are others, but it's two examples. The first one is in Portugal. It was a hospital. The sanction was a fine of a fine of 400,000 euros, and it was issued because of three breaches of the GDPR. First one is a breach of the principles of data integrity and confidentiality, a breach of the principle of limited access to the data. In this case, it was a hospital, and all the doctors could have access to the patient's files with no restriction. So hundreds of doctors had access to the data, and they obviously didn't need to. And it was also a failure for the data controller to guarantee data integrity. So it was an important fine. And the second one was Google. So it's really the most important fine in history of the data protection. And there were two kinds of violations. The first one was a violation of the obligations of transparency and information, meaning that the privacy notice and the privacy policies of Google were insufficient to explain how the data were used by Google for all of its services. And the second one was a violation of the obligation to have a legal basis for ads personalization processing, and the consent obtained by Google from the users were not specific enough and was kind of ambiguous for all of the services provided by Google. Okay, so this is the end of the first part of the introduction. So is there any questions so far?
If anyone has any questions, you can either say them or write them in the chat if you're also don't want to speak.
Okay, well, I will ask if there are some questions at the end of the presentation, if you have questions for what follows. So now, how to comply concretely in two subsections. First is, how do I know when the GDPR applies? So regarding the territorial scope of the GDPR, what you need to know is that, oh, sorry. Okay, sorry. I don't know what just happened. Okay, no.
I can show it on my screen if it works.
Yeah. I don't know what happened. I just. Oh, okay. Maybe it's okay right now. Okay. So territorial scope of the GDPR is that you have two options. First one is that you have an establishment in the EU, like if you are a controller of the personal data or a processor established in the EU, regardless of whether the processing takes place in the EU or not, then the GDPR will apply. The second option is that the controller or the processor is not established in the EU, but the processing activities are related to the offering of goods or services to consumers or to data subjects that are in the EU, or the processing activity concern the monitoring of their behavior as far as their behavior takes place within the EU. For example, a website that targets and follows the behavior online of European citizens, then the GDPR will apply. So there is extraterritorial scope. It's really broad, and it can apply to companies outside of the EU. So here is a summary of the territorial scope of the GDPR. So you can see that either you are a processor or controller in the EU, and then the GDPR will apply, or if not, then you need to ask yourself, is there processing activities related to the offering of goods or services to the data subjects in the EU, or are there processing activities related to the monitoring of the behavior of data subjects in the EU, where the behavior obviously is in the EU? Okay, so now some definitions of the GDPR. So it's now more about the material scope of the GDPR. So the material scope of the GDPR is that it applies to the processing of personal data. So we need to ask ourselves, what is the processing and what are personal data? So GDPR defines personal data as any information related to an identified or identifiable natural person, who are then data subjects. So examples for personal data may be first and last names, obviously, home address, phone numbers, geolocation data, health data, photo, video, IP address, logs. So even, your, for example, behavior online or cookies identifier, things like that, even though they are just numbers and it's just relating to your device or your phone, your computer, it is still personal data, as it can relate to you, even if it's indirectly. And even you cannot find the individual, but you will need to ask other service provider some additional information to isolate and identify the individual. And then even by doing this, all the information will be considered as personal data. So it's really important to understand that. And also, you need to, what is important to remember is that even, like I said, online identifiers or any identifiers used to identify individuals, it is not considered as anonymization. It is only pseudonymized data, and pseudonymization, as defined in the GDPR, it can help reduce privacy risks by making it more difficult to identify individuals, but you should remember that it is still personal data. So all the rules are still applicable. So data retention periods, etc., all of that are still applicable. And if personal data can be truly anonymized, meaning that it is irreversible, you cannot find the individual. For example, it can be statistics or aggregated data. This kind of studies, there can be anonymized data, and then if the data is really anonymized, it is not subject to the GDPR. So it's important to understand what personal data is in order to understand if the data has been anonymized. And then you have the processing, and processing means any operation or set of operations performed on personal data or sets of personal data, whether or not by automated means, such as collection, recording, organization, structuring, storage, anything is a processing. So it's really broad as well. Even if you have data and you don't do anything with it, like you just store it and anybody has any access, but just the data are here, it is still a processing. So example, processing of personal data in the context of an emergency call. You have a processing of personal data. You have the voice, you record the data, you register the data on computer, on files. So it's a processing. Okay, the actors under the GDPR. So you can have two definitions are really important, are the data controller and the data processor. The data controller is the one determining the means and purpose of the processing. For example, an emergency service, a company that initiates the processing. The processor will be the one who processes data on behalf of and under the instructions of the data controller. For example, an emergency service provider. He will be a data processor. He does not define the purpose of the processing, but he just has the data and he processes it on behalf of a controller. You also have a recipient, which receives the personal data. You have the data subjects, which are the natural person to whom data relates to. For example, a person in situation of emergency who calls, he's a data subject. It's always a natural person. And finally, you have the data protection officer, DPO, which is a person internally appointed to monitor and control the data protection compliance. So now 10 common beliefs that people could think they are not concerned by the GDPR for several reasons. So I will go through them. First one would be, I only have a paper file. I don't keep any personal data on my computer. As I said, processing can be on a paper file, and the GDPR is still applicable to paper files. Second one is, I don't process any personal data. It is done by my service provider. As I said before, the service provider is a data processor, so it has specific obligations under the GDPR, and the data controller is still responsible for its service provider. I just read and consult the information. Reading and consulting information and generally having access to an information is a processing of personal data. I don't use any software, only an Excel file or a Word document is also a processing of personal data. I only scan the document and record it on my computer. It's obviously a processing of personal data. I don't collect any sensitive or privacy invasive data. The GDPR applies to any personal data regardless of their sensitivity or privacy invasive or other criteria. So, of course, for sensitive data such as health data, there are more obligations. They are protected with a higher level of protection, but still, for any data which is a personal data, the GDPR and the European framework will apply. I don't collect any first and last name. Okay, so you don't have to have necessarily the first and last name to have personal data, which can lead to identify an individual even if it's indirectly. I only collect financial data. Financial data are personal data. I only collect technical data like IP address, URL, connection data. All of that are considered by the data protection authorities as being personal data. I anonymize data since I only use a number or a code. As I said before, this kind of operation is not necessarily an anonymization within the meaning of the regulation, but it will be mostly a pseudonymization. Or I am a public safety organization. There are no exemption for this kind of organizations, or I am sure there is an exemption for my situation. There is some exception sometimes, but it's not exemption per se to be outside the scope of the GDPR. So now the steps to comply with the GDPR. So first one would be to appoint a pilot in your organization, then checking the lawfulness of the processing, and the third one would be to manage the risks associated with the processing. So you will need basically to have a data mapping, or to map the data that you process in your organization, and then to make a gap assessment to understand what are the points or the issues that would need to be solved, and then to implement the compliance actions to be taken. So first one is to appoint a pilot. So the pilot would be a person responsible for the implementation of the compliance program. So it will be a person in charge of implementing documentation, guidelines, processes, etc., to ensure optimal protection of personal data within the organization. So this pilot, most of the time, will be the data protection officer, the DPO that I already talked about. You will need to know that the DPO can be internal or external to the organization. The DPO is a key element in bringing an organization into compliance with the GDPR throughout the life and activity of the organization. As a law firm, we often advise our clients to appoint a DPO, even though the criteria for appointing a DPO are not necessarily fully met, but sometimes it will be a better element to ensure that there is someone internally who is in charge of these questions. And the DPO is not necessarily just a DPO. It can be someone else. He can have other functions in the company. So who is concerned by the appointment of DPOs? So any public bodies and authorities, and some private companies. For the private companies, it will be if their core activities consist of processing operations that require regular and systematic monitoring of data subjects on a large scale, or if their core activities consist of large-scale processing of sensitive data or data relating to convictions and offenses. So you should know that both data controllers or processors are concerned by these provisions of the GDPR Article 37. However, as I said, for companies that do not meet these criteria, the appointment of a DPO is strongly recommended, especially in big companies or in companies where there are important processing activities. It is a strong indicator of compliance, and it allows organizations to have a contact point for the authorities and for the data subjects. For example, if a data subject come to you to exercise his right to access the personal data or to erase the personal data, if there is a DPO, he will know how to do it, and the contact point will be easily identified for the data subject. So, as an example, in practical, does an emergency service provider providing a solution to manage a disaster event needs a DPO? It could be a software application used for populations in event of a major event or disaster management. And in most cases, the criteria and the conditions of large-scale processing and processing sensitive data, especially health data, will be met. So in those cases, we will think that appointing a DPO will be necessary. But of course, it depends, and it's the assessment is made on a case-by-case basis. So the general missions of a DPO would be to monitor GDPR compliance, to inform and advise the data controller or the data processor, which is the organization that processes the personal data. He would be a contact point for the supervisory authority. He would cooperate with the authority, and he would provide advice on requests to the data controller or to the data processor. So What is important to remember is that the DPO governance is an ongoing and dynamic process. It means that the compliance governance must be organized. Resources and internal organization are required for it to function properly. So you will need to raise awareness among top management and employees, providing training sessions, ensuring that fundamental personal data protection principles are internally implemented. So it's really operational, linked to operational, business, and to the legal. Who can be a DPO? The DPO can be a member of the organization staff, for example, in the legal or in the IT team, or it can be a person from outside the organization. The GDPR says that the DPO shall be designated on the basis of professional qualities and, in particular, expert knowledge of data protection law and practices, and the ability to fulfill the tasks referred to in article that is dedicated to the DPO. But the GDPR does not specify the credentials that DPO are expected to have. It just provides that these qualities should be proportionate to the type of processing carried out. For instance, the complex or risky processing of personal data, such as processing of health data, managing a lot of transfer outside the EU, etc., etc. So the DPO should be qualified with a minimum experience to be able to supervise the processing, and he should be independent. It's really important to remember this quality, because he should be in a situation of absence of conflict of interest, meaning that the DPO cannot perform any function leading to the determination of the purposes and means of processing. He can carry out other tasks and duty, but in independence regarding the processing of personal data. So from a practical point of view, it is frequent that DPO are attached to the compliance department, if any, of course, but because compliance departments often are independent in their advice and recommendations. So checklist when appointing a data protection officer. When appointing a DPO, you need to make sure that the candidate has sufficient legal knowledge on the GDPR, the local data protection laws, data supervisory authorities' way of working, etc. He should easily handle training sessions, audits and implementation of documentation. He should be able to provide advices and recommendations on data protection, such as a PIA, which is a privacy impact assessment. He should be able to act as a contact point for the supervisory authority or the data subject, and he will be fully involved in all data protection matters of the company. And regarding the DPO governance, the DPO must be invited to participate in important internal meetings related to the decision-making in terms of personal data protection. He should be involved in every matter in relation to innovative projects, projects in progress, or project requiring software change or any change on the personal data. And he should carry out and keep up to date a record of the processing activities that reflects the personal data processing operations within the organization. Now, step 2. So what you should know is that for any processing, you should have a legal basis according to the text. You cannot process personal data without a valid legal basis of processing that is specifically listed in the Article 6 of the GDPR. So what can be those legal bases? First one, and the most strong one, would be the consent, that the consumer has given a specific explicit consent to the processing. It can be a contract, that the processing of personal data is necessary for the contract between the organization and the data subject. It can be a legal obligation, meaning that you have to and you must process the personal data in order to comply with laws and regulations, which can be any local law or any European law that you are subject to. Other one can be the vital interests of the data subject. A public task, if the processing of personal data is necessary to perform a task of public interest. And the last one is the legitimate interest of the controller. So if you don't have at least one of those bases for processing, the processing risks to be considered unlawful. And therefore, the data subject will have the right to erase any personal data that has been processed unlawfully. And it is important to remember that the legal basis, that the data subject have a right to be informed about the legal basis that is chosen. So in the privacy notice or in the privacy policy of the organization, you should document and explain the legal basis chosen and why you chose it, if it's to show the relevance of the legal basis. Because the CNIL could consider, the Data Protection Authority could consider that the legal basis that you chose is not adapted, as it is not valid. So it's important to really assess what legal basis is relevant. So small focus on vital interest legal basis, because it can be a legal basis that is interesting for public safety organizations, for example. So Article 6 of the GDPR says that the processing is necessary in order to protect the vital interests of the data subject or any other natural person. A recital 46 of the GDPR also specifies that the processing of personal data should also be regarded as lawful where it is necessary to protect an interest which is essential for the life of the data subject or that of another natural person. Processing of personal data based on the vital interest of another natural person should in principle take place only where the processing cannot be manifestly based on another legal basis. So, for instance, that the consent couldn't be obtained because of the emergency situation, for example. So the vital interest could be used in this case. So the vital interests cover only interests that are absolutely essential to a data subject's life or another person. So, for example, a scheme of emergency call situation. So on the left, you have a data subject that is in an emergency situation. He gives a call to an emergency call center that will transmit the data to emergency services so they can come to the data subject to help him or her. So obviously, there is a processing of personal data, and more specifically sensitive personal data, because you can have health data most of the time, really often. So the emergency call will enable the center to react rapidly and take the necessary steps in rescuing the data subjects. Following the call, the transmission of the data subject's information results in the processing of sensitive data based on a legal basis that could be the vital interest of the data subject. So, focus on sensitive data processing activities. So, as I said, health data are considered as sensitive data, personal data. So, you will have additional conditions on this personal data because they are considered to be more sensitive than other personal data, and it can concern personal data related to the physical or mental health of a natural person, including the provision of healthcare services, which reveal information about the health status of the data subject. So it can be information collected for the purpose of receiving healthcare services, information obtained when examining a part of the body, or information about a disease. So such data, by principle, will need to be processed with the consent of the natural person. Otherwise, it could be considered as unlawful. So there is an exception where specifically you act for the vital interest of the data subject. So the third step is how to manage the risk associated with the processing activities that you are performing. So first, documentation would be to make a privacy impact assessment. So what is a privacy impact assessment? It's a tool that is part of the accountability principle of the data controllers. It helps them not only to build privacy-friendly data processing operations, but also to demonstrate their compliance with the general data protection regulation. And you should know that it is mandatory for processing operations that are likely to generate high risks to the rights and freedoms of the natural person. So if you have identified some risks associated to the processing, it is likely that you will need to perform and conduct a privacy impact assessment. So there are 3 steps to follow to conduct a PIA. The first one will be to describe the processing in order to analyze its inherent risks. To identify, the second step will be to identify the security risks to evaluate their severity and potential impacts on the rights and the freedoms of the data subjects. And the last one will be to address the risks to determine if such risks are acceptable given the technical and organizational measures foreseen. So it's basically the legal assessment. So there are 3 aspects of the PIA: legal, security, and description from an operational point of view of the processing. So the GDPR provides some non-exhaustive examples of situations in which a processing is likely to result in a higher risk, and then a PIA should be carried out. So it can be a processing on a large scale of special categories of data, or personal data relating to criminal convictions and offenses, or a systematic monitoring of a publicly accessible area on a large scale. So in those cases, a PIA should be carried out prior to the processing. It's important to remember that, because you cannot have and implement a processing of personal data and then make the PIA. The PIA should be prior to the processing. It is part of the privacy by design approach that is required by the GDPR. And you should also note that for some projects, PIA will need to be a continuous process and requires to be updated as the project moves forward. Because if there are some important modifications in the processing, in the technology used, for instance, then you should review the PIA and update it to reflect the exact situation. So generally, the Data Protection Authority publish a list of processing that will require a PIA. So, for instance, in France, health data processing carried out by health or medical social institutions for the care of individuals. For this specific processing, a PIA will be needed. And there are guidelines from the European Data Protection Board that has published a list of criteria, and if 2 criteria are met, then the PIA will be mandatory. So this slide is just a practical example of where, if in case of an application used by emergency services and emergency situation to handle emergency situations, those PIA will be required based on the criteria that we just saw. So in this situation, we would have maybe 4 criteria that will be met. First one would be sensitive data. If you are processing health data, you have also location data. If the application allows for the localization of the individual, then you will have location data, which is part of the criteria issued by the European Data Protection Board. The processing is made on a large scale because we may have a lot of persons involved, or we may have a large geographical situation. So it could be considered as a large scale. The processing could be done on vulnerable persons, for instance, on underage or elderly people, or if you use innovative technology, for instance, biometric data, facial recognition, it is considered as innovative technology, and therefore it is a valid criteria that would lead us to think that a PIA will be necessary. And how to carry out a PIA? So there are several steps identified by the French Data Protection Supervisory Authority. First one is to identify the necessity to carry out a PIA, describing the processing and determining the purposes for which such processing are operated, assessing the proportionality of the processing, identifying and assessing the potential risks of such processing for the rights and freedoms of the data subjects, then identifying the technical and organizational measures to mitigate the risks and make them acceptable, integrating the outcomes into an action plan to be able to predict a maximum of events, involving the DPO, able to provide guidance and monitor the compliance. And then the last one will be to assess the necessity of consultation of the Data Protection Authority. Because if at the end of your PIA you think that there is residual risks in the processing, then you should consult with your local Data Protection Authority. And last advice that I could give is that the CNIL, the French Data Protection Authority, has published a software that you could download online, and it's a model, a template to complete a PIA. So it's available in 18 languages, so it can be useful. Okay, and last one is an example of an emergency video call application with a few key principles of the GDPR. So first one, data minimization. So for this kind of application, it will be necessary to collect accident location, geolocation data, but it will not be needed to collect data relating to the personal address of the person in the emergency situation. Transparency. You should provide information to the user of the system and to obtain the user's consent and be able to demonstrate that you have user's consent. But there is no need to obtain the victim's consent while collecting his or her personal data. If you use the legal basis, as I said before, of the protection of vital interests, you will not need to have the victim's consent. Then you need to ensure that the application respects the data subject's rights and enable them to exercise their right of access, eraser, etc. And then you should follow the accountability principle by having updated and maintaining a record of the processing activities and conducting a PIA if you think that it will be necessary regarding the risks that are associated to your processing of personal data. Thank you everyone for attending this webinar. If you have any questions, feel free to question.
I think we have a question in the chat, so I'm just going to read it out for you. So the question is from Andre, and he says, if a company to which the GDPR regulations apply has a data leak, for example, a severe cyber attack, in spite of its security measures, would that company suffer any sanctions? Does it depend on the risks which have been reviewed and accepted beforehand? I don't know if you have
yeah. No, I understand the question. Well, it will depend, because if you have a data leak, in spite of your security measure, you will need to notify this leak to your data protection authority. You will have to do it within 72 hours. It is required by the GDPR. So if you do that, and then if you implement the corrective measures that are necessary to solve the breach, then you could be okay. But if you don't notify the data breach, and if you don't take the appropriate measures to resolve this breach, then you can be sanctioned by the data protection authority. So the GDPR and the regulator knows that there is no zero risks. There are always risks, especially regarding the new technologies or new uses. And it does not impose to have a zero risk policy or zero attacks or zero data breach. You can have it, but if you endure such a situation, you should report it and take the necessary steps to protect the data subjects, to protect the data, and to resolve the breach.
Does anyone have any more questions? If not, I will just show where we can find the document, because obviously that's quite a lot of information. And so if you would like to find some more information, you can view this document where the link is there. This was also written by Bird&Bird, and it's full of very useful information. I can't seem to show it properly on the screen, but I think you can all see the link there, so you can take a look at this. And also, just to let you know that this session has also been recorded, so if you want to go back and see some of the information that has been shared kindly by Alexandre, you can also go back and have a look at that information. So yes, I'd advise you to take a look at the document, take a look at the recording to get some more information. So the last thing is just to say thank you so much to Alexandre for this webinar. It's been super interesting, and I think we all go away with a lot more information about GDPR. So thank you so much. If anyone has any more questions, you can either say now, or you can also send me an email. I put it there on the screen, which is rm@eena.org. So you can send me an email if you have any more questions about the document or about the webinar recordings, which will be uploaded in the next days. So thank you so much for everyone for attending the webinar, and thank you especially for Alexandre from Bird&Bird for this really informative presentation.
Thank you to you all, and bye-bye.
Bye, everyone. Thank you so much.
Thank you very much.
Thank you for a great presentation.
Thank you, everyone. Bye.